Test, test, test. So here we go. This is Virginia Giuffre, the plaintiff, Ghislaine Maxwell, the defendant. This is United States District Court, Southern District Court of New York. So, this is a document everybody's raving about, right? Smiling, whooping, saying how they're going to show it on their channel later, charging to what for this information. United States District Court, Southern District Court of New York, Virginia. L. Giuffre, plaintiff, case number 15 CV 07433 RWS v. Ghislaine Maxwell, defendant. Plaintiff redacted motion to compel defendant to answer deposition questions filed under Seal 1. Plaintiff Virginia Giuffre, by and through her undersigned counsel, hereby files this motion to compel defendant to answer deposition questions. During her recent deposition, defendant refused to answer numerous questions about allegedly adult sexual activity related to Jeffrey Epstein, the pedo bastard. Because this activity is highly relevant to this case, defendant should be ordered to answer questions about it. As the court is aware, this defamation case involves Miss Giuffre's assertions that she and other females were recruited by defendant to be sexually abused by Jeffrey Epstein under the guise of being massage therapists. See complaint DE1 at 27. Giuffre described Maxwell's role as one of the main women who Epstein used to procure underage girls for sexual activities and the primary conspirator and participant in his sexual abuse and sex trafficking scheme. In response to these assertions, defendant has made the sweeping claim that Ms. Giuffre's assertions are entirely false and entirely untrue. Complaint DE1 at 31. Defendant has labelled her entire deposition transcript as confidential at this time. Counsel for the parties conferred at the deposition regarding answering questions. Yes, during her deposition, defendant refused to answer any questions that she construed as having something to do with consensual adult sex. Defence counsel supported that position that, frankly, that's none of your business and I instruct the witness not to answer. See Declaration of Sigrid S. Macaulay Declaration at Exhibit 1 of Maxwell deposition. That was April the 22nd, 2016. The result was that at a number of points throughout her deposition, defendant refused to answer questions about subjects integral to this lawsuit, including questions about what the alleged massage therapists were doing at Jeffrey Epstein's house and the sexual nature of those massages. For example, defendant refused to answer questions about whether she had given Jeffrey Epstein a massage. Question: have you ever given Jeffrey Epstein a massage? Mr. Paglucci, object to the form foundation, and I'm going to instruct you not to answer that question. I do not have any problem with you asking questions about what the subject matter of this lawsuit is, which would be, as you've termed it, sexual trafficking of Miss Roberts. To the extent you are asking for information relating to any consensual adult interaction between my client and Mr. Epstein, I'm going to instruct her not to answer because it was not part of this litigation and it is her private confidential information, not subject to this deposition. Miss Macaulay, you can instruct her not to answer. That is your right. But I will bring her back for another deposition because it is part of the subject matter of this litigation, so she should be answering these questions. This is a civil litigation deposition and she should be responsible for answering these questions. Mr. Pagluska, I disagree and you understand the bound that I put on it. Miss Macaulay, no I don't. I will continue to ask my questions and you continue to make your objections. Question: did you ever participate from the time period of 1992 to 2009? Did you ever participate in a massage with Jeffrey Epstein and another female? Question mark. Mr. Plaguka: objection. Do not answer that question. Again, to the extent you are asking for some sort of illegal activity as you're construed in connection with this case, I don't have any problem with you asking that question to the extent these questions involve consensual acts between adults. Frankly, they're none of your business and will instruct the witness not to answer. Miss Macaulay: this case involves sexual trafficking, sexual abuse. Questions about her having interactions with other females is relevant to this case. She needs to answer these questions. Mr. Plaguka: I'm instructing her not to answer. Miss Macaulay: then we will be back here again. See Macaulay Declaration at Exhibit 2 of the Maxwell deposition, April 22nd, 2016. At 20 to 22, emphasis added. Defendant participation in massages with Epstein is a central part of this case. Miss Gouffre has explained that during her first sexual encounter with Jeffrey Epstein, it was the defendant who provided instruction on how to do it and how to turn the massage into a sexual event. Obviously, proof that the defendant had previously massaged Epstein, include massages with sexual component, would provide important corroboration for Miss Gouffre's testimony at trial, and proof that defendant was involved in massages will further help prove that statements to the press that Virginia's allegations were obviously lies was itself an obviously lie. As another example, defendant refused to answer questions about her knowledge that Joanna Josberg was hired to work for Epstein and provide massages. In the police report, Joanna admitted that Maxwell recruited her to work for Epstein. See Macaulay Declaration at Exhibit 3. Gouffre 00076-77. Police report indicating that Joanna was recruited by Maxwell in brackets. Yet, during defendant's deposition, she refused to answer questions regarding Joanna Josberg. Question: do you know what task Joanna was hired to perform? Answer: she was tasked to answer telephones. Question: did you ever ask her to rub Jeffrey's feet? Answer: I believe that I have read that, but I do not have any memory of it. So, were you involved in Jeffrey's massages? I was always happy to give career advice to people, and I think that becoming somebody in the healthcare profession, either exercise instructor or nutritionist or professional massage therapist, is an excellent job opportunity. Hourly wages are around $7 to $9, and as a professional healthcare provider you can earn somewhere between, as we have established, $100 to $200. And to be able to travel and have a job that pays that is a wonderful job opportunity. So in the content of advising people for opportunities for work, it is possible that I would have said that she should explore that as an option. Question: did you tell her she would get extra money if she massaged Jeffrey? Answer: I'm just saying I cannot recall the exact conversation. I gave her career advice and I've done that. Question: did you ever have Joanna massage you? Answer: I did. Question: how many times? Question mark. Answer: I don't recall how many times. Question: was there sex involved? Answer: no. Question: did you ever have sexual contact with Joanna? Question mark. Mr. Pagluka: object to the former and foundation. You need to give me an opportunity to get in between the questions. Anything that involves consensual sex on your part, I'm instructing you not to answer. Question: did you ever have sexual contact with Joanna? Question mark. Answer: Mr. Pagluka: again, she is an adult. Question: I'm asking you, did you ever have sexual contact with Joanna? Question mark. Answer: I've just been instructed not to answer. Question: on what basis? Question mark. Answer: you have to ask my lawyer. See Macaulay, Declaration at Exhibit 4 of Maxwell deposition, April 22nd, 2016 at 60-62, emphasis added in brackets. Here again, this information is critical to the case. Among other things, these questions are designed to show a modus operandi, MO, for Epstein and Maxwell, specifically how they recruited for a non-sexual massage, then converted the massage into sexual activities. One last illustration comes from the defendant's refusal to answer for her knowledge of Epstein's sexual interest during massages. Question: does Jeffrey like to have his nipples pinched during sexual encounters? Question mark. Mr. Pagluka, objection to form and foundation. Maxwell answers, I'm not referring to any advice on my counsel. I'm not talking about any adult sexual things when I was with him. Question: when Jeffrey would have a massage, would he request that the masseuse pinch his nipples while he was having a massage? Question mark. Maxwell answers, I'm not talking about anything with consensual adult situation. See Macaulay, Declaration at Exhibit 5 of Maxwell deposition, April 22nd, 2016, in brackets, at 82. While Epstein himself might also provide answers to these questions, it appears likely that he will assert his Fifth Amendment privilege regarding his sexual activities. Accordingly, Ms. Giuffre must pursue question of Maxwell to obtain information on this subject. Here again, information about Epstein's sexual idiosyncrasies, and provide information corroboration to Ms. Giuffre's testimony that she had sexual interactions of an identical nature with Epstein. These refusals are not an isolated instance. Instead, similar refusals to answer questions occurred repeatedly throughout the deposition. CEG Macaulay Declaration at Composite Exhibition 6, 52 to 55, 64 to 65, 82, 92 to 93, 137 to 38, 307 to 309. The court should compel the defendant to answer all these questions. In addition to the specific points made above, the big picture here reveals how vital such discovery is. At the core of Ms. Giuffre's allegations is the allegation that defendant lured her into a sexual situation with the offer of a job making money as a massage therapist, that Epstein always habitually tried to turn massages into sex. In brackets, that was his modus operandi and plan all along, end of brackets. And that Maxwell recruited other females for an ostensibly proper position, such as therapeutic masseuse, with the knowledge that the intent was for that person would be pressured to provide sexual gratification to Epstein. As a result, Epstein's use of massage for sexual purposes is a central part of this case. And defendant's role in these massages and knowledge of the purposes of those massages is a critical piece of evidence showing her state of mind when she attacked Miss Giuffre's assertions as entirely untrue. Miss Giuffre intends to prove at trial that defendant knew full well the sexual purposes for which she was recruiting females, including underage females like Miss Giuffre. Miss Giuffre is entitled to explore defendant's knowledge of these sexual activities that took place under the guise of massages. Otherwise, defendant will be able to portray to the jury an inaccurate picture of what was happening at Epstein's house was nothing more than run-of-the-mill massage therapy. CEG Macaulay Declaration at Exhibit 7 of Maxwell deposition, April 22nd, 2016 at 51, in brackets, question: did pay for massage therapists? Right, so that's, did the payment, how much they earned, vary on what sexual acts they performed? Question mark. Answer from Maxwell: no, it varied depending on how much time. Some massage therapists charged more and some less. Defendant's refusal to answer questions was about alleged adult consensual sex. Also blocks Miss Giuffre from seeking legitimate discovery at this case. By refusing to answer questions about her and Epstein's sexual activities with alleged adults, Defendant is essentially given the ability to refuse to answer any sexual question and she does not wish to answer. Defendant simply has to deem the question as involving consensual adult sex and no need to be given. The result is to leave Miss Giuffre with no way of exploring the identity of these alleged adults, the ages of these alleged adults, and indeed whether they were adults at all. This allows defendant to claim that she is unaware of any sexual activity involving underage females because she claims the only sexual activity she was aware of involved adults. The court should compel Miss Maxwell to answer all questions about her knowledge relating to sexual activities with Epstein and other females while at Epstein's various homes. See Federal R. Criminal, page 37. Oh, this is bollocks. Let's just move on. Under the federal rules, when a party refuses to answer a question during a deposition, the questioning party may subsequently move to compel disclosure of the testimony that is sought. The court must determine the propriety of the deponent's objection to answering the questions and can order the deponent to provide improperly withheld answers during the continued deposition. In brackets, internal citations omitted. End of brackets. Of course, the party objecting to discovery must carry the burden of proving the validity of his objections, particularly in light of the broad and liberal construction afforded to the federal discovery rules. John Wiley & Sons Incorporated v. Book Dog Books. For purposes of deposition, the information sought need not be admissible at the trial if the discovery appears reasonably calculated to lead to the discovery of admissible evidence. Chen and Oster v. Goldman, Sachs and Co. These are just examples. Defendant cannot carry her burden of showing that the questions asked are not reasonably calculated to lead to the discovery of admissible evidence. This is a case in which sexual activities lie at the heart of the issues in dispute. As a result, it is hardly surprising to find that discovery pertains to alleged adult sexual activities and questions about such subjects are entirely proper. So, we move on now in this document. So the plaintiff is hereby ordered to answer questions regarding her sexual activities so far as they are relevant to a defence of substantial truth, mitigation of damages, or impeachment of plaintiff. So these are giving you examples again. So basically this bitch isn't wanting to talk. So let's move into this a bit more. So this case, private matters are clearly relevant to subject matter of the suit. Accordingly, plaintiff Miss Webster shall respond to the defendant's interrogations concerning of sexual partners. That's a bracket. Generally speaking, instructions from attorneys to their client not to answer questions at deposition should be limited to issue regarding privileges. Morales v. Zondo, another example. So basically, the counsel ranged far beyond the normal parameters of objection, sought to decide for himself what the issues were relevant. That was improper, and the court should order a resumption of the defendant's deposition so that she can answer questions about her knowledge of sexual activity relating to Jeffrey Epstein. Conclusion: defendant should be ordered to sit for a follow-up deposition and direct answer questions. So that's all 2016, is that? Let me just check this out, man. I fucking feel sick now. So excuse me for losing the place there. I'm gonna have to invest. I've got other documents. I have the full list of the black. I have the black book, and I also have the flight details, all of them. This is fucking sick. I thought these were fresh. I don't know. If anybody knows, let me know. My head has gone on this already. So bear with me till I try and work this out. I'm going to upload this anyway because I'm not doing it again. Cheers. These bastards make me sick. How she can sit there, right, and not answer those questions. Fucking dirty, filthy scumbag bastards.